Hello and welcome back. My name is Soumya Uma and I work as Assistant Professor of Law in Maharashtra National Law University, Mumbai. In the last module, we discussed some of the international standards on juvenile justice. We learnt about the provisions of ICCPR, the Beijing Rules, the Convention on the Rights of the Child, and a general comment issued by the committee established under the CRC, that is General Comment number 10 on aspects of juvenile justice. This forms the bedrock or the foundation of international standards on administration of juvenile justice and the rights of juveniles while engaging with the juvenile justice system. In the present module, which is module number 4, we will discuss other international standards which complement the standards that we have already learnt about. These standards are Riyadh Guidelines 1990, the Havana Rules 1990 and the Vienna Guidelines 1997. Additionally, we will move closer home and look at some normative standards applicable to SAARC countries, including India. This module will end with a discussion on the interface of international standards with the Indian law and practice pertaining to juvenile justice system by analyzing the observations and recommendations made by UN committees and other mechanisms on the juvenile justice system in India. So now let us start with the first guidelines in this module, that is the UN guidelines for the prevention of juvenile delinquency 1990. I will be referring to them as the Riyadh guidelines. The preventive aspect of juvenile delinquency was subsequently elaborated upon in the 1990 UN guidelines, which are also called the Riyadh guidelines. As the title suggests, these guidelines were restricted to juvenile delinquency alone, and they were restricted to the preventive aspects of the same. The guidelines build upon and elaborate the previous international standards, and they provide a comprehensive framework and policy guidelines for preventing juvenile delinquency. These guidelines are founded upon principles of best interest of the child and the child's right to development. The guidelines are based on the assumption that prevention of juvenile delinquency could consequently lead to prevention of occurrence of other crimes in society once the children and the juveniles grow up. The emphasis on prevention helps to promote the general welfare of children and young persons and aids their development to their fullest potential, which is very, very important. Further, the guidelines emphasize upon social reintegration in terms of reuniting the child with his or her family, as the family is regarded as the place where the child is most safe and where an all-around development of the child takes place. Of course, this presumption could be challenged in some contexts. The guidelines consist of 66 paragraphs and they are divided into 7 parts, namely, first part which deals with fundamental principles. This part emphasizes on prevention of juvenile delinquency as a part of crime prevention, the need for a child-centered orientation, the importance of preventive measures from the juvenile's early childhood, and that official intervention should be guided by fairness, equity, and best interests of the child. The guidelines come down heavily on the labeling of a young person as a deviant, a delinquent, a pre-delinquent. As such, labeling often contributes to the development of a consistent pattern of undesirable behavior by young persons. The guidelines also propose community-based services and programs for preventing juvenile delinquency. The second part deals with the scope of these guidelines. The scope of the guidelines ought to be interpreted and implemented within a broad human rights framework consisting of the Universal Declaration of Human Rights, that is UDHR, the International Covenant on Economic, Social and Cultural Rights, which is called the ICESCR, the International Covenant on Civil and Political Rights called ICCPR, which we discussed in the previous module, the Declaration of the Rights of the Child and the Convention on the Rights of the Child, which also we discussed in the previous module in the context of the UN Standard Minimum Rules for the administration of juvenile justice, which is the Beijing rules, which you already know about because of last module, as well as other instruments pertaining to juveniles. There is a further mention that these guidelines should be implemented in the context of the economic, social and cultural conditions which are prevailing in each member state. The third part of these guidelines consists of general prevention. The guidelines call upon each government to formulate comprehensive preventive plans at each level, which should include in-depth analysis of the problem, well-defined responsibilities for qualified personnel. Thirdly, mechanisms for coordinating prevention efforts among governmental and non-governmental agencies and community involvement in the same. The fourth part of these guidelines deal with what is called the socialization process. This part of the guidelines lays special emphasis on the role of the family, education, community and mass media, peer groups, vocational training and the world of work to successful socialization and integration of children and young persons with a perspective that they are partners in the process. The fifth part of these guidelines deal with what is called social policy. The guidelines also emphasize the important role of governments in giving high priority to social policy and programs for young people with sufficient funds and infrastructure. It reiterates institutionalization of children as a last resort. The sixth part of these guidelines deal with legislation and juvenile justice administration. The guidelines emphasize on the duty of the governments to formulate and to effectively implement laws and procedures to prevent victimization, abuse, exploitation of children, as well as to protect and promote rights of children in conflict with the law. The guidelines reiterate that no child or young person should be subjected to any harsh or degrading punishment measures either at home or in school or in any other institution. The guidelines encourage governments to formulate laws that would restrict or control children's access to weapons. Training of law enforcement and other such personnel has also been emphasized. The seventh part of the guidelines deal with research, policy development and coordination. The guidelines in this part emphasize on the need to undertake scientific research on prevention of juvenile delinquency as well as interdisciplinary and multidisciplinary interaction and coordination among various agencies. So, we see that there is an emphasis on scientific research once again, as in some of the earlier international standards that we have discussed in the earlier module. Now let us look at another set of rules. This is called the UN rules for the protection of juveniles deprived of their liberty. This is also called the Havana Rules 1990. In the same year, in response to prevailing practices internationally in the treatment of juveniles deprived of their liberty, the UN General Assembly adopted these rules, which I will hereafter refer to as the Havana Rules. While the Riyadh guidelines, which we discussed just now, focused on preventive aspects of juvenile delinquency, the Havana Rules elaborated upon protecting the rights of those juveniles who were deprived of their liberty. So these are two separate standards which should be seen as complementing each other, as well as strengthening and reiterating each other's standards, as well as those standards which were set by the Beijing rules and the CRC. So together all of them elaborate on varied aspects of juvenile justice. The central aspect of the Havana Rules is the definition of the term juveniles deprived of their liberty. This definition is as follows. Deprivation of liberty means any form of detention or imprisonment or the placement of a person under the age of 18 in a public or private custodial setting from which this person is not permitted to leave at will by order of any judicial, administrative or other public authority. This is found in Rule 11B of these Havana Rules. The Havana Rules operate to ensure that juvenile detainees and offenders are given fair treatment and receive consideration for their age. This UN agenda acts to counterbalance the growing trend of decreasing the age of criminal responsibility in domestic law to enable children below 18 years of age to be prosecuted for criminal offences on par with adults. This is a phenomenon we have seen in India as well. The Havana Rules have reiterated the importance of reintegration, rehabilitation and reformation by stating that juveniles who are detained in institutions should be guaranteed the benefit of meaningful activities and programs which would serve to promote and sustain their health and self-respect, to foster their sense of responsibility and encourage those attitudes and skills that will assist them in developing their potentials as members of society. The rules provide for detailed standards of treatment for juveniles under arrest or awaiting trial. These include 1. The right to presumption of innocence. 2. Detention before trial should be limited to exceptional circumstances. 3. Speedy trial to ensure detention for the shortest possible duration. 4. Right to legal counsel. 5. Right to free legal aid. 6. Privacy and confidentiality for communications with legal counsel. 7. Opportunity to pursue work with remuneration, education, training during detention. This should not be compulsory and should not be the reason for extending the period of detention. And 8. Right to leisure and recreation. The centerpiece of the Havana Rules, spelt out in great detail, are with regard to the management of juvenile facilities. These are found in Rules 19 to Rule 80. The rules provide guidelines for 1. Maintaining records, 2. Admission, registration, movement and transfer, 3. Classification of juveniles and their placement according to the specific type and level of care that each juvenile requires, 4. Separation of adults from juveniles in the detention facilities, 5. The establishment of open detention facilities, 6. Physical environment and accommodation including sanitary installations, 7. Provision of education, vocational training and work, 8. Provision of recreation, 9. Availability of medical care, 10. Provision of religious facilities, 11. Notification of illness, injury and death to the family or guardian of the juvenile, 12. Facilities for contacts with the outside world and with the wider community, 13. Use of instruments of physical restraint and use of force only in exceptional circumstances for the shortest possible time and without causing humiliation and degradation. 14. Prohibition of carrying and use of weapons by personnel in juvenile detention facilities. 15. Prohibition of disciplinary measures which may be cruel, inhuman or degrading treatment including corporal treatment. 16. Prohibition of placement in a dark cell, in closed or solitary confinement. 17. Need for conducting unannounced inspections at the detention facilities by other authorities. 18. Assistance to juveniles to return to society, family life, education and employment after release. The Havana rules also emphasize issues pertaining to personnel to the detention facilities such as their recruitment, training, composition and qualifications. These are found in rules 81 to 86. In short, the Havana rules have contributed substantially to the standard of treatment of juveniles in detention facilities. Now, let us look at the next set of guidelines, that is the UN Guidelines for Action on Children in the Juvenile Justice Systems. These are called the Vienna Guidelines for Action in 1997. In 1997, the UN General Assembly adopted the UN Guidelines for Action on Children in the Juvenile Justice Systems. Developed by an expert group in Vienna on 23rd to 25th February of 1997, these guidelines are an aid in giving effect to existing standards by formulating not another set of principles but a program of action to promote the effective use and application of international standards and norms in juvenile justice. The expert group consisted of 29 experts from 11 countries in different parts of the world, coupled with representatives of the Center for Human Rights of the UN Secretariat, the United Nations Children's Fund, which is known as UNICEF, and the Committee on the Rights of the Child, as well as observers for NGOs concerned with juvenile justice. All of these people participated in this meeting. The Vienna Guidelines for Action are addressed to various stakeholders such as 1. The UN Secretary General, 2. Relevant UN agencies and programs, 3. States parties to the Convention on the Rights of the Child, which includes India, 4. Member states as regards the use and application of the UN Standard Minimum Rules for the Administration of Juvenile Justice, which is the Beijing Rules, which we have already discussed in the last module. And fifth, the United Nations Guidelines for the Prevention of Juvenile Delinquency, which is the Riyadh Guidelines, which we discussed just now, as well as the Havana Rules, which are together referred to as the UN Standards and Norms in Juvenile Justice. In order to ensure effective use of the 1997 guidelines, it underlined the need for improving cooperation between governments, relevant UN bodies, NGOs, and all professional groups such as media, academic institutions, children, and other members of civil society. In spelling out measures that pertain to formulation of law and policy, decision making, leadership, and reform, the guidelines state that the goals should be that the principles and provisions of the CRC and the UN standards and norms in general in juvenile justice, such as the Beijing Rules, Riyadh Guidelines, Havana Rules, and Vienna Guidelines for Action, are fully reflected in national and local policy and law of countries. Specifically, these principles and provisions aim at establishment of a juvenile justice system that is fair and humane and which guarantees rights of children. Secondly, preventing the violation of rights of juveniles. Thirdly, preventing juvenile delinquency. Fourthly, promotion of children's sense of dignity and worth. And fifthly, respect for children's age, stage of development, right to be heard and to participate meaningfully and to contribute to society. The guidelines state that the effective implementation of the Convention on the Rights of the Child, as well as the use and application of international standards through technical cooperation and advisory service programs, should be ensured by giving attention to the following: A. Assistance in legal reform. B. Strengthening national capacities and infrastructures. C. Training programs for all officials concerned with juvenile justice. D. Preparation in training modules. E. Preparation and information and educational material to inform children about their rights in juvenile justice. And 6. Assistance with development of information and management systems. The Vienna Guidelines are a useful set of guidelines for governments to have a clearer understanding of ways in which their obligation under the CRC can be discharged by domestically formulating and implementing these standards through laws and policies. Given the history of India, which has had a spate of amendments to its law on juvenile justice, these guidelines serve as useful pointers on how Indian law on juvenile justice can keep pace with and conform to international standards. Now let us look at the SAARC Convention on Regional Arrangement for Promotion of Child Welfare, 2002. The SAARC, which is the South Asian Association for Regional Cooperation, as all of you know, is a regional body. It has representatives from 8 countries, namely Afghanistan, Bangladesh, Bhutan, India, Nepal, Pakistan, Sri Lanka, and the Maldives. Founded in 1985, one of the aims of SAARC is to advocate for the welfare of the people of South Asia so as to improve the quality of their lives, an issue on which the SAARC countries have come together and developed regional standards is on child rights. SAARC observed the decade of the rights of the child in the years 2001 to 2010. During the decade in 2002, the SAARC countries adopted the Convention on Promotion of Child Welfare in South Asia. Now I will refer to it as the SAARC Convention. The purpose behind the formulation of this convention was to concretize and consolidate the commitments made by South Asian governments to the UN bodies and effectively implement the same through mutual cooperation and assistance. Article 7 of the SAARC Convention, dealing with promotion of the rights and well-being of the child, forms the crux of this convention. The salient features of this convention, which apply to all the South Asian countries including India, are as follows. Firstly, the convention defines a child as any person who has not completed 18 years of age, who is a national of one of the countries in the region. Secondly, the convention focuses on protecting the rights of the child while realizing the full potential of each child. Thirdly, it reiterates state obligation to give recognition to rights of the child as laid down in the CRC and to be guided by the best interest of the child at all times. Fourthly, it upholds the rights of the family as a primary caregiver. Fifthly, it calls upon the state parties to take effective measures for the rehabilitation and reintegration of children in conflict with the law. Sixthly, it emphasizes education and health services for their preventive and curative roles. Seventhly, the SAARC Convention also underlines the need for appropriate legal and administrative systems such as national laws to protect the child from abuse, exploitation, neglect, violence, discrimination, trafficking and child labor. This is emphasized as a regional priority. Eighthly, a commitment is made by the state parties to the SAARC Convention to take appropriate measures for the rehabilitation of street children, orphaned, displaced and abandoned children and children affected by armed conflict. Ninthly, the SAARC Convention recognizes the need to establish child-friendly juvenile justice systems. Tenthly, the state parties also resolved to take all appropriate measures to protect children from the illicit use of narcotic drugs and psychotropic substances. It is important to remember that the commitments that the governments have made to themselves under the SAARC Convention are in addition to, and they do not substitute, the commitments that they have made under the CRC or other international standards. However, the SAARC Convention is very significant as it is an emerging regional human rights standard on juvenile justice, which has incorporated the basic principles of juvenile justice that form the crux of the international normative standards. Regional cooperation on the issue of juvenile justice is a very important aspect which will be facilitated and promoted through this convention. So, although the SAARC Convention is of extreme significance, to what extent have the SAARC members actually been able to comply with those standards related to juvenile justice is something that I've given in detail in the notes. So please read the notes to be able to understand what is the reality and what is it that is desired from every SAARC country, including India. Now we will look at the observation of UN mechanisms on juvenile justice with regard to India. India ratified the UN Convention on the Rights of the Child in 1992. Ratification of an international treaty brings with it an obligation on the part of the government to incorporate the standards set in the same within the domestic laws. Under Article 43 of the CRC, a committee on the rights of the child was constituted for examining the progress made by states parties in implementing the provisions of the CRC. Concluding observations of the CRC in the year 2000, let us try and understand this. The Indian government submitted its initial report in 1997, which was considered by the Committee on the Child Rights in January 2000. The committee expressed concern over the very young age of criminal responsibility and the possibility of boys within the age group of 16 to 18 being prosecuted in court as an adult, as the domestic law defined a juvenile as a boy of less than 16 years of age. The committee also raised its concern at overcrowding and unsanitary condition of detention of children, including detention with adults, lack of enforcement of the law, and lack of training for relevant personnel. The committee made the following recommendations. 1. India should review its law on juvenile justice in order to ensure that it is in accordance with the CRC, especially Articles 37, 39 and 40 and other relevant international standards such as the Beijing Rules, the Riyadh Guidelines and the Vienna Guidelines. Second, the committee suggested that India should abolish by law the imposition of death penalty on persons under 18 years of age. Thirdly, it recommended raising the age of criminal responsibility and ensuring that persons under 18 are not tried as adults. Fourthly, the unequal definition of juvenile boys, which is below 16 years, and juvenile girls, which is below 18 years, in the Juvenile Justice Act should be amended. Fifthly, measures should be taken to reduce overcrowding in places of detention. And lastly, need for speedy trials to be conducted. Pursuant to these observations, the Juvenile Justice Act was amended in the year 2000 and to bring it more in conformity with international standards. This has been discussed in Module 2 on juvenile justice. Now let us look at the concluding observations of the Child Rights Committee in 2004. In 2004, the committee had another chance to examine closely the functioning of the Juvenile Justice Administration in India when it considered the second periodic report of the Indian government with regard to status of compliance with the provisions of the CRC. In this report too, the committee addressed the issue of juvenile justice. It called upon the Indian government to 1. Take all appropriate measures to implement a juvenile justice system that is in conformity with the Child Rights Convention, in particular Articles 37, 39 and 40, and with other UN standards in this field. 2. Amend the Juvenile Justice Care and Protection of Children Act 2000 to set a minimum age of criminal responsibility that should be higher than that fixed in the penal code, and it should reflect internationally accepted norms and consider this age as the age when the offence was committed. 3. Extend the application of the Juvenile Justice, Care and Protection of Children Act 2000 to the state of Jammu and Kashmir. 4. Take all necessary steps to establish as a matter of urgency the executing state mechanisms necessary for the full implementation of the Juvenile Justice, Care and Protection Act 2000. 5. Strengthen training programs on relevant international standards for all the professionals involved with the system of juvenile justice. 6. Strengthen rehabilitation and reintegration programs. 7. Use deprivation of liberty only as a measure of last resort. And lastly, 8. Consider seeking technical assistance from, among others, especially United Nations Office of the High Commissioner of Human Rights, that is OHCHR, and UNICEF. General comment on the CRC on the minimum age of criminal responsibility 2007. It is important to note that the concluding observations are made with regard to a particular country, whereas general comments that the Child Rights Committee issues, these would deal with interpretation of the provisions of the treaty, that is, interpretation of provisions of the Child Rights Convention, and make it applicable to all parties. In 2007, the committee made its general comments on minimum age of criminal responsibility, and this comment is also applicable to India, particularly in view of the 2015 amendment to the Juvenile Justice Act. In para 38 of this general comment, it recommended that states parties which limit the applicability of their juvenile justice rules to children under the age of 16 years, or which allow by way of exception that 16 or 17-year-old children are treated as adult criminals, they should change their laws with a view to achieving a non-discriminatory full application of their juvenile justice rules, which are applicable to all persons under the age of 18 years. Now let's look at the concluding observations of the Child Rights Committee, which were made with regard to India in the year 2014. In 2014, the Committee for Rights of the Child made its concluding observations to the Indian government's third and fourth periodic reports. It expressed serious concern at various aspects. Let me highlight some of them. 1. Indications that India plans to lower the minimum age of criminal responsibility stated in the Juvenile Justice Rules of 2007. 2. The very limited knowledge, sensitivity and capacity of the staff working at the juvenile justice boards to handle cases involving children in conflict with the law, and the lack of adequate oversight of the boards. 3. The inadequacy of the information management system to collect data on children in conflict with the law, time spent on pending cases, the general functioning of the boards, including the nature and quality of orders issued by the boards, and the role and functioning of the special juvenile police units. 4. The lack of age-appropriate separation of children in conflict with the law in observation homes, which are intended for temporary reception and upon completion of an inquiry, and special homes for children who have been sentenced, and cases of children in conflict with the law being housed together with children in need of care and protection. Its recommendations to the Indian government included the following. Firstly, bring the juvenile justice system fully in line with the CRC and other relevant international standards. Secondly, give effect to the Juvenile Justice Rules of 2007, which establish the minimum age of criminal responsibility at 18 years and maintain the minimum age at an internationally acceptable level. Thirdly, provide the juvenile justice boards with adequate human, technical and financial resources as well as training for the personnel. Fourthly, provide free or subsidized legal aid and other appropriate assistance to children in conflict with the law at an early stage of the procedure and afterwards throughout the legal proceedings. Fifthly, to promote alternative measures to detention such as diversion, probation, mediation, counseling or community service wherever necessary and wherever possible. Sixthly, use detention only as a last resort and for the shortest possible period of time and ensure that it is reviewed on a regular basis with a view to withdrawing it. Seventhly, in cases where detention is necessary, ensure age-appropriate separation of children in observation and special homes and ensure that children in conflict with the law are not detained together with children in need of protection or with adults, and that detention conditions are compliant with international standards, including with regard to access to education and health services. And lastly, to accomplish all of these recommendations, it called upon India to make use of the technical assistance tools developed by the Interagency Panel on Juvenile Justice and its members, including UNODC, UNICEF, OHCHR and NGOs. Now let us conclude this module. In conclusion, the juvenile justice system in India is not perfect and continues to be evolving and developing, with the Indian government taking efforts to bring the same in conformity with the provisions of the CRC as well as other international legal standards such as the Beijing Rules, the Riyadh Guidelines, the Havana Rules and Vienna Guidelines, all of which we have discussed in the last module and this module. Although these rules and guidelines do not enjoy the same binding effect on the Indian government as the ICCPR or the CRC, they are standards that have potential to guide the formulation and the amendment of domestic legislations and procedures. The SAARC Convention adds to the effort of regional efforts by providing regional arrangements and regional cooperation to implement the international standards on juvenile justice. It should not be forgotten that the ultimate goal of such an effort is to protect, promote and respect the human rights of juveniles in conflict with the law and those in need of care and protection. With this, we end the fourth and the last module on juvenile justice. Please read the notes, the references, look at the PowerPoint presentations as well as other information that's available on the internet in order to add on to the information that I have provided in this module. Thank you.